Thank you. Welcome, everybody. Thank you for joining CyFAR's 2021 Cal-Peculiarities Series 4 session on rounding and meal periods. All participants are in listen-only mode right now. If you have any questions throughout the program, please use the Q&A section located on the right side of your WebEx window. We'll do our best to make sure that everyone's questions get answered either during the course of the presentation or towards the end if we've got some more time then. If not, we'll make sure to follow up with you via email. The Q&A will show your name and we'll be able to contact you that way. Additionally, like I said, if there is additional time at the end, we'll be able to answer some of the Q&As that way with time permitting. For those of you who are interested in obtaining CLE credit, there will be an attendance verification code that will be read during the presentation. Please make sure to write this code down. It won't be repeated, and it is required to obtain the CLE credit. The CLE credit instructions for submission, as well as a recording of the presentation and the slide deck itself, will be distributed to the attendees in the days following this presentation. Our favorite part of all webinars is the legal disclaimer, and so we just want to make sure that everyone understands that this presentation has been prepared by CyFAR Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or as a legal opinion on any specific facts or circumstances. The content is intended just for general information purposes only, and you're urged to consult your favorite CyFAR lawyer or any other outside lawyer that you may have concerning your own situation and any specific legal questions that you may have. We'd be more than happy to talk to you regarding your situations and any of those questions after the presentation. My name is Michael Afar. I'm one of the associates in the Labor and Employment Department for the Los Angeles Century City office. I'm joined by two of my esteemed colleagues, Elizabeth McGregor, who works up north in San Francisco, who's also an associate, as well as David Rosenberg, another associate in our Century City office as well. You'll see on your screen a high-level agenda of the sort of four main points that we'll be covering today. The first is sort of background on meal periods and rounding, which is the subject of this webinar, and in particular, a summary of the key Dontahue decision that came out this year and all of the key holdings, especially how they relate to meal periods and rounding. Dontahue provides a good recent guidepost on the context of the legal state for meal periods and rounding, and we'll be sure to cover all the key points there. On the second part of the agenda, we'll discuss the rise of the rebuttable presumption, starting from the Brinker decision and its official codification now through the Dontahue decision. And then we'll move on into rebutting this presumption, including practical solutions and common applications, as well as some recent developments in the class action context and how that rebuttable presumption may play itself out for large-scale class or representative actions. And then finally, we'll cover some best practices regarding meal period and rest periods, the impact of rounding, and some timekeeping attestations. So for our first subject today, we'll be covering the summary of meal periods and rounding, and for that, I'll turn it over to Elizabeth to get started.
Thanks, Michael. So we'll just start by talking about a brief overview of California law on meal period and rounding. Go to the next slide. So the main case on meal periods in California is Brinker versus Superior Court. In that case, the California Supreme Court clarified a number of requirements related to meal periods. The court held that an employer's duty with respect to meal breaks is an obligation to provide meal breaks to its employees. The court explained that an employer provides a meal break if it relieves the employees of all duty, relinquishes control over their activities, and permits them a reasonable opportunity to take an uninterrupted 30-minute break and does not impede or discourage them from doing so. The court also clarified timing requirements for meal periods. It said that the first meal period has to be taken before the end of the employee's 5th hour of work. So if an employee begins work at 8 a.m., the meal period has to begin before 1 p.m. And similarly, for second meal periods, the meal period has to begin before the end of the 10th hour of work. In terms of making sure that employees take meal periods, the court wrote that employers are not required to police meal breaks to make sure that no work is performed. The court wrote, if work does continue, the employer will not be liable for premium pay. At most, it will be liable for straight pay, and then only when it knew or reasonably should have known that the worker was working through the authorized meal break. We can go to the next slide. And with regard to rounding, the California Supreme Court hasn't really opined on rounding, but several appellate courts have. One of them is Seas Candy versus Superior Court. In that case, the court wrote that California law permits employers to use a rounding policy for recording and compensating employee time, as long as the employer's rounding policy does not consistently result in a failure to pay employees for time worked. The court wrote that a rounding policy is lawful if it's fair and neutral on its face, and if it's used in such a manner that will not result over a period of time in failure to compensate employees properly for all the time they've actually worked. So to be neutral on its face, a rounding policy can't be applied so that it only favors the employer. For example, if an employer has a rounding policy where all early punches get rounded up to the start of the hour, but late punches don't also get rounded back to the start of the hour, then only the employer benefits from that policy. The employee will never be paid a few extra minutes for time not worked, and it will never net out over time in that respect. So that would be an example of a non-neutral policy that would not be allowed. In Seas Candy, the court found that assuming a rounding overtime policy is neutral, both facially and as applied, the practice is proper under California law because its net effect is to permit employers to efficiently calculate hours worked without imposing any burden on employees. Next slide, please. So now we'll briefly discuss the key holdings in the Dontahue decision and some of the facts. Next slide, please. So in Dontahue, the plaintiff worked as a nurse recruiter for AMN, and AMN had a timekeeping system that rounded punches to the nearest 10-minute increment. The rounding applied at both the start and end of shifts, and also at the start and end of meal periods. So for example, if somebody clocked out for a meal period at 12:02 and clocked back in at 12:25, that meal period would round to look like a full 30-minute meal period, even though it was only 23 minutes. And similarly, if somebody clocked in for a shift at 6:59 and clocked out for a meal period at 12:04, those time punches would also round so that it looked like the person had received a meal period right at the 5-hour mark, when in fact it was actually a few minutes late. AMN relied on rounded time in determining whether or not to pay employees for a meal period. And before September 2012, the timekeeping system would pay meal premiums automatically if there was a short, missed, or late meal period, but it would only flag short, late, or missed based on rounded time. So there were some apparently non-compliant meal periods or potentially non-compliant meal periods that weren't being flagged for that. After September 2012, there was a drop-down menu that allowed employees to say whether they had shortened their meal period by choice or voluntarily skipped a meal period, or to say that they hadn't been provided with a meal period. And if the employer chose the option saying they hadn't been provided with a meal period, they would receive a premium. But again, as with the pre-2012 automatic payments, that drop-down menu was only triggered by rounded time. Employees also signed a certification statement at the end of each biweekly pay period saying that their time entries were accurate and that they'd been provided with the opportunity to take all the meal periods, all of their meal periods. And if the employees hadn't been provided with a meal period, they could report it on that certification at that time. AMN argued that its practice of meal period rounding evened out over time and that its rounding practices resulted overall in an overcompensation of the class, and that the average length of nurse recruiters' meal periods was approximately 45 minutes on average. Next slide, please. Dontahue had two key holdings. The first is that employers cannot engage in the practice of rounding time punches in the meal period context. And the second is that the court held that time records showing apparently non-compliant meal periods give rise to a rebuttable presumption of meal period violations. And then it's the employer's duty to rebut that presumption. Next slide, please. And so now we'll talk about the rise of that rebuttable presumption. Next slide, please. So the idea of the rebuttable presumption traces itself back to Justice Werdiger's concurrence in the Brinker decision. In that concurrence, Justice Werdiger wrote that under the wage order, the employer has an obligation to both relieve the employee for a meal period and to record having done so. She also wrote that if there's no record of a meal period, a rebuttable presumption arises that the employee was not relieved of duty and that no meal period was provided. The Dontahue court quoted Justice Werdiger's concurrence, writing, "An employer's assertion that it did relieve the employee of duty, but the employee waived the opportunity to have a work-free break is not an element the plaintiff must disprove as part of the plaintiff's case in chief. Rather, the assertion is an affirmative defense, and thus the burden is on the employer as the party asserting waiver to plead and prove it." In adopting Justice Werdiger's concurrence, the Dontahue court noted that a number of courts of appeals had cited Werdiger's concurrence approvingly. Brinker had also held, as I said earlier, that employers are not required to police meal periods to make sure that no work is performed during a meal period. AMN argued that applying the rebuttable presumption would essentially result in automatic liability for employers and would thus be undermining that statement in Brinker. The court said, however, that that wasn't the case and that employers can rebut the presumption by presenting evidence that employees were compensated for non-compliant meal periods or that they had in fact been provided with compliant meal periods but chose not to take them. Next slide, please. And now I'll hand it over to Michael to discuss how to rebut the presumption.
Thanks, Elizabeth. So the first way that we're seeing employers look at rebutting this presumption, and this is a format that's been routinely affirmed by courts, including in the Dontahue decision as being a viable way of rebutting the presumption, is the automatic payment of meal period premiums. And what employers can do is to automatically have a system that pays the meal period premiums based on apparently non-compliant meal periods as reflected on the employee's time records. So some examples of that would be if just based on the raw data punches on an employee's electronic time records, you see that the meal break was taken later than the 5th hour of work, or the meal period was short in that it was 29 minutes, things like that. And the system would be designed in a way where just based on those facially non-compliant meal periods, an automatic premium payment would be issued to that employee. That's very helpful in terms of managing individual and class liability because paying out the premium is effectuating the obligation under the labor code for these sorts of facial violations. The problem with automatic meal period premiums is that it doesn't completely eliminate liability in a PAGA action. The California Supreme Court in Kim v. Raines was very clear that civil penalties that are available under the PAGA statute are different than the statutory penalties that would need to be paid out for a meal period violation. And so even if an employer does pay out that meal period premium, that still doesn't extinguish an employee's right to try and recover civil penalties under the PAGA statute. The other consideration with the meal period premiums and automatic payment is that it can result in employers overpaying for meal period premiums in the aggregate. Oftentimes you might see that employees start to understand the system or even take advantage of it by doing things like waiting until 1 minute after the 5th hour of work to take their meal period, even though they were able to and provided that meal period at an earlier point, just so that they can trigger that premium payment, or taking a meal period that's only 29 minutes, even though they're fully able to take the full 30 minutes. In the overall sort of scheme of things, it's still better to have a system in place that does pay out the automatic meal period premiums with a backup system in place that allows for managers to review all of the instances where premiums are paid out, have disciplinary measures in place where if they see that employees are abusing the system or if employees are having regular problems, as we call it, of potential meal period violations, that managerial level employee can have a conversation with these employees and try to ensure that the employees are taking their lawful 30-minute meal breaks. Next slide, please. Another system that has come to light in recent years, but especially after the Dontahue decision, is to have an attestation process where employees attest on a daily basis whether or not they received a compliant meal period in the electronic timekeeping system. This was approved by Dontahue, and the Dontahue court specifically said that this type of time tracking system that has a drop down where employees can indicate whether they were provided a compliant meal period and whether that system then triggered premium pay for any missed or short or late meal periods, that would satisfy the employer's burden of rebutting the presumption. The important thing is to make sure that that system is happening on a regular basis, ideally on a daily basis, so that employees are answering that question in real time and that it's being tracked in a way that can later be used to show that employees did answer these attestation questions on a daily basis. Next slide, please. One other way to rebut the presumption is through the use of representative testimony, surveys, and statistical analysis. And the Dontahue court specifically said that employers can rebut the presumption by presenting evidence that employees were compensated for these non-compliant meal periods, or that they had in fact been provided with these meal periods, which they chose to either forego or work through for their own personal choice. The specific issues with representative testimony or surveys or statistical analysis is to be cautious that there is the danger of potentially conceding that this sample somehow renders a larger class action or representative action to be quote unquote manageable in some way that would fairly and efficiently allow the case to be litigated. And that's an important distinction to note because it's important for a defendant to make sure that they're reminding the court and raising their affirmative defense that they're entitled to show for each and every employee whether or not they were provided with a meal period or whether the employee chose to not take it and what those particular reasons were. Representative testimony or statistics can be a double-edged sword in a lot of ways, where an employer can try to use it to show widespread compliance, but it can also backfire in ways where a plaintiff can argue, well, a sample of a few hundred employees should be sufficient to somehow show widespread liability for a class of thousands and thousands of potential class members. And so it's important to be mindful of how that statistical evidence is being used. Next slide, please. Since the Dontahue decision came out, one of the cases since then has been the case called Salazar v. See's Candy. It's a published California Court of Appeal decision that came out a few months ago, and it's the first decision that applied the rebuttable presumption in the context of a class action case and how that affirmative defense that an employer has to show that they did provide a meal period to each employee would factor into whether a class action can be certified. For background on the Salazar case, the plaintiff had relied heavily on a scheduling form that was pre-printed that did not contain a column for a second meal break on days where an employee worked more than 10 hours. And there was conflicting evidence in the record with See's Candy submitting 55 employee declarations that employees did in fact take meal breaks, their second ones, but with time records showing a high percentage, almost 75% of shifts over 10 hours actually not having a second meal break. In light of that evidence, the trial court concluded that at least some class members were offered that second meal period, and so there would still be a need for individual testimony to show whether See's consistently had an unlawful practice, and that this individual testimony would result in a series of mini trials. The trial court further held that Salazar had failed to provide a trial plan that would permit See's to present this affirmative defense without all of the individualized inquiries that would be needed. And on those bases, it denied class certification. When it got to the Court of Appeal, Salazar had argued that the recent Dontahue decision made this issue of an affirmative defense one that should not preclude class certification. In other words, the class should still be certified, and the affirmative defense is See's burden to worry about at some later stage when it gets to that point, but it should not preclude class certification. But the Court of Appeal rejected that argument. The Court of Appeal held that this argument about individual testimony and how it concerned an affirmative defense did not change the analysis. And the court held that where an employer fails to provide the time records showing that a meal break was taken, the presumption can arise that employees were not offered such a break, but then the employer can use that affirmative defense to show all of the issues as to whether the employee did or did not, in fact, get a lawful meal period or whether it was their choice to forego it. And the Court of Appeal held that the individual issues arising from C's affirmative defense precluded certification, and that it was within the trial court's discretion to deny class certification, particularly relying on the decision in the Duran case, where the California Supreme Court held that in certifying a class action, the court has to also ensure that litigation of individual issues, including those that arise from affirmative defenses, can be managed fairly and efficiently. And so it's important to remember that even though there is a rebuttable presumption on potential meal period violations, that cannot infringe on the substantive rights and the defendant's affirmative defense rights to present those offenses and show that there are individualized issues as to whether or not the meal periods were taken. Next slide. Now we'll kick it over to David to talk about best practices.
All right, now that we've covered some basics on meal periods and rounding, as well as a summary of the Dontahue decision and its key holdings, I wanted to spend some time talking about best practices when it comes to rounding, meal and rest periods, and timekeeping attestation systems. Since the Dontahue decision came down, a lot of clients have been asking whether it is a precursor to the end of rounding. Well, the short answer is that the Dontahue court expressly stated that it was not addressing the lawfulness of rounding outside of the meal period context. But the California Supreme Court did go out of its way to point out that it has never decided the validity of rounding, and that it has not adopted the rounding standards articulated by the Court of Appeals in the C's Candy decision that Elizabeth covered at the beginning of this webinar. In addition, the Dontahue court suggested that rounding has likely outlived its usefulness, and that technological advances now allow employers to track time more precisely. The court also made references to the fact that rounding policies appear rather pointless because they require an employer to take the extra step of taking an actual punch time and then rounding it to the nearest quarter or other increment of time. So in light of the Dontahue court's discussion on rounding, the practical advice we've been giving to employers is that they should move away from rounding entirely if they haven't already. We believe the Dontahue decision is a warning to employers that the next time the issue of rounding comes up, the California Supreme Court will likely hold that it is unlawful, and that employers should not be surprised if the decision is retroactive in nature. Before we get to timekeeping attestations, I also think it's worth spending a little time discussing the backbone of any good attestation system. All good attestation systems must be premised on lawful meal and rest break policies. And so before thinking about your potential options for implementing an attestation system, we recommend that you review your company's meal and rest period policies to ensure that they're up to date and comply with the nuances of California law. We also recommend that you implement employee and supervisor trainings to ensure that meal and rest period practices actually conform with your written policies. Your training programs don't need to be overly complex, and we have many templates and samples that we could easily modify for your company's industries and workforce. In addition to having lawful policies and appropriate training programs in place, we recommend getting employee acknowledgments stating that they received the policies, that they read and understood them, and that they were trained on them. This way, if you ever faced with any claims alleging any meal and rest break violations, you'll be able to show that employees were aware of and trained on your policies. Finally, we recommend that you ensure that the applicable wage order for your company's industry is posted in each of the company's locations or facilities. Not only is this required by law, but it also acts as another means by which you've made employees aware of their meal and rest period entitlements. Earlier in the presentation, Elizabeth mentioned that the court in Dontahue held that employers cannot round employee time punches in the meal period context. So if you haven't done so already, please be sure that your company has eliminated meal period rounding in the meal period context as soon as possible. In addition to the items we've already covered, employers should also consider other options available to them to help limit meal and rest period exposure. These options include providing meal periods that are 35 minutes or longer. Although the law only requires employers to provide 30-minute meal periods, employers can limit exposure to short meal periods of 28 or 29 minutes by simply providing employees with meal periods that are 35 minutes or longer. In a similar vein, while the law only requires that employers authorize and permit 10-minute rest periods, Another option for limiting potential exposure is to allow employees to take 15-minute rest periods. This way you avoid any arguments that they weren't provided at least a net 10 minutes if, that break is short by a minute or two. In addition to meal periods that are short by a minute or two, we also come across meal period records that show a lot of breaks that are late by only a few minutes. As Elizabeth mentioned, because employers need to provide a first meal period before the end of an employee's 5th hour of work, we suggest that meal periods be scheduled at least 30 minutes, if not an hour before then. A lot of our clients are also now using scheduling software that incorporates California's meal and rest period requirements to help ensure that all required breaks are scheduled in conformance with California law. This type of software helps take the guesswork out of the equation and is a helpful tool for supervisory level employees who regularly prepare employee schedules. As Mike mentioned, another way to limit potential exposure is to automatically pay a premium whenever an employee's time records show a facially non-compliant meal break. While this option will definitely help limit exposure, at least in the class context, it's not one that we recommend. As Mike mentioned, this option is very costly and in many cases will lead to the overpayment of premiums in situations where employees voluntarily decide to take a short or late meal break or to skip it altogether. The automatic payment of premiums may also lead to employee abuse, as Mike mentioned, if they figure out they can game the system by taking only a slightly shorter late meal break and receiving an extra hour of pay for their efforts. Another option, and one that we highly recommend, is that employers implement a timekeeping attestation system that will help increase compliance numbers and significantly reduce exposure without the additional costs associated with the automatic payment of meal period premiums. For those who are unfamiliar, a timekeeping attestation system is something that can be integrated into your current timekeeping system. When you have a timekeeping attestation, the timekeeping system will generate various prompts that ask employees, to attest whether they have been provided with compliant meal and rest breaks, and also whether they have accurately recorded all hours worked. While Dontahue doesn't require employers to implement this type of system, we believe that best practices do. And if you're interested in implementing one, there are a range of ways to approach the process, with some options providing more protection than others. So what should an attestation cover? The ideal attestation will prompt employees to certify that the hours that they have recorded account for all hours that they have worked, and to certify that they were provided with compliant meal and rest periods. The next logical question is, why should I even consider going through the effort of implementing these systems? Well, an attestation system can help with a few things. First, it can help reduce potential exposure for facially non-compliant breaks without the additional costs associated with the automatic payment of premiums. An attestation system also creates a record to help overcome Dontahue's rebuttable presumption for meal periods, as well as potential claims for off-the-clock work. This way, if you're ever faced with a lawsuit, you already have a lot of helpful evidence to defeat the claims asserted without the cost or expense of conducting employee interviews and gathering employee declarations. Attestation reports also allow employers to conduct periodic audits of the attestation records to help spot employee abuse and compliance deficiencies before the company is ever faced with a potential lawsuit. So what does a typical attestation look like? Here I've provided an example of a very basic attestation that asks the employee to attest that their time records accurately identify all hours worked and that the employee was provided with all relevant meal and rest periods. After the Dontahue decision, I think employers should consider adding a second sentence to this type of attestation that could read something along the lines of, I was not required to miss any meal or rest periods or to take any short or late meal or rest periods, and that any, non-compliant breaks were a result of my voluntary choice. As I mentioned earlier, attestations come in many different forms. One example of a meal period attestation is as follows. When an employee goes to clock out for the day, the employee will be asked if they were provided with all of their breaks as provided in the company's written policies. If the employee selects agree, then the process ends and the employee should be clocked out for the day. However, if the employee selects disagree, additional screens should prompt the employee to answer more specific questions regarding their meal periods. For example, the system may include a drop-down menu that allows the employee to identify if the issue was a late missed or short meal period and whether it was voluntary or not. And if the employee selects involuntary, then the employee should be provided with a meal period premium. In the interest of time, I'm going to skip to our next and last substantive slide on timekeeping attestations. When it comes to best practices for timekeeping attestations, the employee's should an employee's time reflect the time spent completing the attestation process? And the answer is yes. The final punch-out time should be after the conclusion of the attestation procedure, and the time spent completing it should be paid. As Mike mentioned earlier in the presentation, another question we've been getting a lot is whether attestation should be done daily, weekly, or at the end of each pay period. And while there's no real right or wrong answer here, we believe that attestations are strongest when they are daily. Finally, we've been asked whether employees should be able to view the time punches that they're actually attesting to during the process. And again, the answer is yes. Employees should be able to clearly view all relevant time punches for the period that they're attesting to, including punches in and out for meals. And I know we're running over a little bit, so I'll get to the CLE code and wrap up here pretty quickly. The CLE code for today's webinar is SS, as in Seyfarth Shaw, 2218. Again, that's SS 2218. As Mike mentioned at the beginning of the program, CLE credit submission instructions, the presentation recording, and the PowerPoint slides we've been presenting on will be distributed to attendees in the next couple days. When you receive the slides, please be sure to check out some of our firm's other Cal-Peculiarity webinars if you missed them, and also be sure to check out some of the firm's other resources and publications on California peculiarities in the employment law space. I know we've gone over a few minutes here, so I'm just going to quickly, on behalf of Michael, Elizabeth, and myself, thank you all for attending today, and we appreciate it.
Thank you, everyone. And I'll note that we have a lot of questions that came in. We'll do our best to try and respond to everybody offline, but feel free to please email any one of us, and we'd be happy to help answer some questions that you have.